Hello and welcome to the webinar. On behalf of the Law Office of Tyler R. Barrett, PLLC, I want to say thank you for joining us today. So for this month's webinar, we are going to do a little recap. So what you are about to see are some highlights from our previous webinar series, just to do a final review. Then in May, so next month, we will begin our new webinar series. So with that, I hope you enjoy these highlights and we look forward to seeing you in May.
Or what are the different types of estate plans? So there's several different types of estate plans. The first is to do nothing. Now, surprisingly, studies and estimates show that about 50% of Americans do not even have a basic will. So there are a lot of people who have chosen this option to do nothing as it relates to their estate plan. The second option is the use of joint tenancy, beneficiary designations, and transfer on death deeds. So a little better than the first type of plan, but still not ideal in my opinion. There thirdly would be a will-centered estate plan. So this is referring to a last will and testament. And then finally, there would be a trust-centered estate plan, which for the reasons that I'll speak about later, I think is the best plan available to most people. So how does your estate work without a will? Let's take a moment to think about and kind of parse what exactly an estate is. I tell clients simply, an estate is everything you own. So it's all your investments, family heirlooms, personal property, your bank accounts, your 401k, your house, and your other real estate. If you do not have a will, all of this, all of your estate ends up in probate court. So we mentioned the fees could be thousands of dollars involved in a probate. What's more, if your estate ends up in probate court, then the government, through intestacy laws, as they're called, determines who are your heirs, meaning who inherits your estate. And in some cases, that could be the people that you want to have your stuff. But most of the time, it's not. And so an example that I use here is Prince. So I'll spare you my rendition of Purple Rain, although singing is a hidden talent of mine. But Prince had tens of millions of dollars, world famous recording artist, a massive, massive estate. And believe it or not, he died without a will. And so what happened there? Well, in Prince's case, half brothers and half sisters, some of whom he hadn't spoken to in decades, ended up inheriting his estate. And I imagine that those are not the people that he would have wanted to have it, but they did end up getting it. Eventually, the case, last I heard, was still tied up in probate court, and in fact, it may be to this day. And so that's what can happen if you don't have a will and your estate is in probate court. And then there are also the tax issues. We talked about the income and estate tax issues involved in all estate planning. But if you don't have a will, this is something that can be especially acute in probate court. Okay, let's talk about the next type of plan. And this is a popular one. A lot of people are cognizant of probate and they're aware that it's a bad thing and it should be avoided. So they try to do that with joint tenancy, transfer on death deeds, and beneficiary designations. So those transfer on death deeds are especially popular here in Oklahoma. I'm sure many of you have heard of them. So how do those work and what are the pitfalls there? So a lot of clients have multiple children, and with a transfer on death deed, they may seek to just put one child on there, thinking that they would be in charge of what happens with the house and how all that unfolds. So the reality is, if you put one child on a transfer on death deed, and let's say you have 3 children total, the other 2 are totally cut out of your estate. So some people would say, okay, well that makes sense. I'll just put all 3 of my kids on the transfer on death deed. In limited instances, that might be okay and that could work. But let's consider for a moment what happens if the beneficiaries disagree. So, three children all on the transfer on death deed. The way this works under Oklahoma law is that they're equal co-owners, so 1/3 each of the property. Let's say that two out of the three decide the house should be sold and the money split up accordingly. But one of the children is holding out. One of the children does not want to sell the property. Well, now all of a sudden the property cannot be sold. The title company will not issue the insurance or close the sale, and your estate could end up right back in court, in the probate court. And it's, and then all the attendant fees and costs with that, and the family discord that would create, is now back in the picture. And so we definitely, we'll do transfer on death deeds for certain clients, but I think most of the time there are better ways to structure your estate plan. Along the same lines are beneficiary designations. So many of us have maybe heard of payable on death beneficiaries. Oftentimes, banks and financial companies will ask you to name a payable on death beneficiary. So what is that, and what does that do? So payable on death designation is a private contract between the account holder and the financial institution to pay those funds over to the named beneficiary upon the account holder's death. So that does in fact avoid probate, which is a plus. On the downside, however, is that you lose all control of the money at that point. So if you remember back a few minutes ago when we were discussing what I call spendthrifts, or attacks by creditors, divorcing spouses, other third parties, a payable on death or beneficiary designation does not protect against those. So the money is paid outright to the beneficiary, where it could be lost, through malfeasance, through irresponsibility, or due to a third party trying to take those funds. So a little bit better than no estate plan at all, but still not optimal because of the things that I mentioned. So how does your estate work with a will? That's kind of the next step up. A last will and testament. So a last will and testament is your instructions to the probate court regarding how your stuff is to be dispersed. And so it's a little bit better, I think, than beneficiary designation, because we can actually do some things to protect the assets, maybe direct how the money is to be spent or for what purposes. So it's a little bit better than beneficiary designations in that regard, but it falls short in the area of probate. So a will, contrary to the belief that some have, still requires probate. I think we've all probably seen those Law and Order episodes or legal thrillers where somebody dies and everybody gathers around at the attorney's office, and the attorney pulls the will out of the safe and starts reading, Johnny gets this, Susie gets that. It would be nice if that's how it works, but it doesn't. And so a will does require probate, and will be tied up in court for at least a few months, if not much longer, particularly if there are any disputes. So a will's better than nothing, but it's not the best. What is the best plan? So I think, in my opinion, a trust is going to be the best estate plan for most of the clients that I work with. What is a trust? So a trust is a legal arrangement that has been around for thousands of years, whereby you transfer assets into a trust to be held by your trustee for the benefit of your beneficiaries on the terms and conditions of your choosing. So a trust has several advantages when it comes to estate planning. It avoids probate. So, I know I harp on probate a lot, but that is a major advantage of the trust, is avoiding probate. It also offers a level of privacy that we don't have with wills or even with transfer on death deeds and beneficiary designations. So in the vast majority of cases, the only parties who ever know about a trust and know its contents are the attorney who drafted it, the client or clients themselves, and the beneficiaries. So under Oklahoma law, other family members who may not be part of a trust are not entitled to see the documents. And therefore, the privacy is maintained. What I really think trusts do a great job of, though, is asset protection. And so I've read a number of different things about this, studies and whatnot. But about 50% of wealth is lost after the first generation, and 75% of wealth is lost by the second generation. So whether it's $200,000, $800,000, $8 million, the fact remains that we all work very hard for what we have. And it would just be devastating to see it lost, due to poor estate planning. And so, what we can do with a trust is basically the possibilities are endless. We can dictate if the children or the beneficiaries are younger, that their access to the trust or their distribution is staggered on certain ages. So maybe they get 1/3 at 25, another third at 35, and then they get the balance of the trust when they're 45. Perhaps you, as the client, have certain things that you want to encourage your beneficiaries to do. So maybe you want to encourage your beneficiaries to pursue higher education, to start a business, to buy a home. There could be many other things that you want to do as far as passing down your values to that next generation. And with a trust, you can tie distributions from the trust and access to the trust to achievement of those things, or limit distribution to those purposes. Finally, you can structure the trust so that it is just, I don't want to say foolproof, because nothing is foolproof in life, but you can have an independent trustee, such as a bank or a trust company, with full discretion to make or not make distributions. And that's the most protective type of trust that we can arrange for a client. So with that discretionary trust, as we refer to it, you are all but guaranteeing that no one other than the beneficiary is going to have access to the money. And that can be very, very important for some people, especially those with very large estates. So for all of those reasons, a trust is, I believe, the best estate plan possible. Do want to make a caveat here, though. All of those benefits that I just covered are contingent upon the trust being fully funded. So what do I mean by fully funded? A trust does require a little bit more work on our behalf and on the client's behalf than does a will, because we have to actually go through and transfer or retitle assets in the name of the trust. So what does that mean? We need to deed the client's home out of their individual names and into the name of the trust. We need to retitle the client's bank accounts in the name of the trust, update beneficiaries on retirement plans and life insurance. If you fail to do those things, if you fail to fully fund your trust, then your estate could end up in probate anyway, thereby defeating the purpose of the plan. So it is vital that that be followed up on. So what the heck is a successor trustee? Put simply, a successor trustee is the person or entity who manages the trust for the benefit of your beneficiaries. Now, typically, the successor trustee does not take over until after your death. However, there are instances in which the successor trustee can begin acting while you're still alive. For example, if you have Alzheimer's or dementia or suffered a stroke and your doctor says that you're no longer capable of managing your finances, The successor trustee can step right in and just pick up where you left off. And that's a major advantage of trust over wills or even durable powers of attorney is the successor trustee can start acting on your behalf and on behalf of the beneficiaries without any sort of court involvement. What are the duties and responsibilities of a successor trustee? So to begin with, they need to locate the relevant estate planning documents. Of course, this is the trust, but it also includes your will, your durable power of attorney for healthcare and finances, and your advance directive for healthcare. Without all of these documents, the successor trustee is not going to be able to conduct a full and complete administration of the trust. So beyond that, the successor trustee will want to locate the assets of the trust. So this might mean tracking down deeds for real estate or mineral rights, securing statements for checking and savings accounts, securing beneficiary forms for retirement accounts and life insurance, all of those sorts of things so that the trustee knows what they're dealing with and what property belongs to the trust. Once they have identified all of the relevant estate planning documents, tracked down and marshaled the assets of the trust, I advise successor trustees to meet with your trusted team of advisors or your trusted team of professionals. So hopefully you have an estate planning attorney, a CPA, a financial advisor, all those people who kind of set up your financial life and made sure the wheels kept turning. So the successor trustee should meet with all of those people to make sure that everyone is on the same page. So the last responsibility of a successor trustee before administering or distributing the trust is to handle any expenses, debts, taxes that may be owed. So the saying goes, death and taxes are the only things certain in life. Well, guess what? You got to pay taxes even after you die. So that's something the successor trustee is going to handle for you. After the successor trustee has paid those expenses, they can begin administering the trust. And the key point here is that the successor trustee has what we call fiduciary duty. That's just fancy legal speak for the successor trustee has a legal obligation to act in the best interest not of themselves, but rather of the beneficiaries and the trust as a whole. So the successor trustee can engage in self-dealing, do transactions that only benefit himself or herself, use the trust as a slush fund, anything like that. All those things are off limits, and the trustee has to follow the instructions that you have left for them in the trust document, and then conduct that administration in the best interest of the beneficiaries. So how do you pick a successor trustee? So I just always tell clients, of course, how and when the assets of the trust are distributed and to whom is something that we need to focus on. But probably the number one choice in all of estate planning with trust is whom you select as the successor trustee, because the wrong person can cause a lot of havoc and can undo the best laid plans. So what do I advise my clients to look for or to think about when they are picking their successor trustee? So I think geography is important. Now, it's not as critical as it used to be, say 30 years ago because of social media, email, computers, tablets, etc. But it does help to have a successor trustee in the same location when possible. We also want to look at the capability of the successor trustee. So by that I mean, are they going to be able to carry out the job that you're tapping them to do? I think we all have strengths and weaknesses in life, and we all have family members who are maybe great at healthcare decisions, very empathetic, very nice people, but just when it comes to finances, that's not something that they deal with very readily. So if that's the case, you may not want to select that person. We also want to really discuss and think about what kind of relationship does the beneficiaries of the trust have with your proposed successor trustee. So family harmony. I always am just really attuned to maintain that family harmony. I don't want to do anything in an estate plan that can damage the family or put them at odds with one another. But unfortunately, choosing the wrong successor trustee can do just that. So we want to look at the relationship of the beneficiaries and the successor trustee to make sure they get along, make sure there is a level of trust there that can allow the administration and distribution of the trust to move forward. There's a couple different types of successor trustees. So one would be an interested or non-professional trustee. That usually is a family member, so it could be your son, daughter, brother, sister, etc. The advantage of an interested or non-professional trustee is that they usually have a pretty good handle on the family dynamics. They may know, or they likely know a lot about the history of the family, and they are not necessarily going to charge the fees that you might see with a professional or corporate trustee. So it can really lower the costs for everybody involved. Disadvantages, they may not be willing to serve as successor trustee. So I kind of joke with clients sometimes that everybody wants to be a successor trustee until they actually are, and then they're like, "Whoa, holy cow, this is a lot of work." So that's something to keep in mind too. And just going back to the knowledge factor, if you have a complicated estate, even somebody who's very intelligent may not have the time or resources to manage that. So that can be kind of where the professional or corporate trustee really comes into play. And so that's your banks, your trust companies, but it could also be an accountant, another attorney, something like that. And so the advantage of the professional or independent trustee is expertise in management of the trust. They kind of, conversely from an interested trustee or a non-professional trustee, kind of have a level of detachment from the trust, which may make it more likely that they will administer it in an unbiased way for the benefit of all beneficiaries. And really, if asset protection is your goal, you're going to set up a trust that continues on for a number of years. That can lighten the burden on the family. Your children have their trust, it carries on. They don't have to worry about it. It's there for them when they need it. The disadvantages of a professional or corporate trustee, I think, are the fees. So those can be kind of high depending on whom you select as the corporate or professional trustee. So that's something to keep in mind. Unless you have a large estate, and by that I mean maybe over $1 million, a corporate or professional trustee may not make sense. So definitely think about that when choosing your trustee. What can you do to set up your successor trustee for success? So I guess I have to say this because I get calls at my office on a somewhat regular basis with children inquiring, if their mom or dad set up a trust with me or set up a will with me. So they're just actually calling around to attorneys across town, trying to find out what estate plan, if any, their parents had. So that's all to say. Tell your successor trustee that you have a trust. You don't necessarily need to share all the details of that document with them right away, but they need to know that you have it. They need to know who to contact if you were to pass away. The next thing is to really have them talk with the attorney and establish a relationship with an attorney. Again, you may not want to do this during the planning stages. We don't want any undue influence while you're deciding on the details of the plan. But afterwards, I think it's very helpful to have the successor trustee meet with the attorney who prepared the plan, discuss the plan, and so they at least have some advance notice on what's going to be expected of them. The other thing would be trust funding. So this is something that gets missed a lot. And in my office, we really harp on trust funding with our clients. And by that, I mean making sure that trust assets or that the client's assets are titled in the name of the trust or have the trust as beneficiary so that the successor trustee can manage those assets. If there are assets that don't have any beneficiary, aren't titled in the trust, then the successor trustee doesn't have any sway over those assets, or at the least may have to go to probate court to manage to get control and management of those assets. So knowledge of the plan, trust funding, those are the two main things you can do to set up your successor trustee. When I think of estate planning, I always come back to legacy. What legacy do we want to leave behind for our loved ones? Legacy encompasses many things, but a big part of it is family harmony. We all know a family that has been ripped apart by a trust or estate dispute. These are tragic instances, and yet they are ones that are so avoidable. The successor trustee, by virtue of spearheading the trust administration process, is in the best position to promote family harmony and to keep the family together, provided that they follow diligently their duties and responsibilities under the law. The duties and responsibilities of a successor trustee are varied, so I will cover just the essentials for the purpose of this webinar. First and foremost, a successor trustee must gather the assets of the trust and safeguard those assets. After all, the distribution of property to beneficiaries is the main purpose of estate planning. Beyond that, a successor trustee must be adept at communication. I tell successor trustees, communicate, communicate, and communicate some more. We have to be honest with ourselves here. As human beings, if we're kept in the dark, we naturally assume the worst. We assume that something must be wrong. So the successor trustee can never communicate too much. And often, trust and estate disputes boil down to a mere lack of communication. Now, the successor trustee is also going to want to make sure that all of the deceased's legal and financial obligations are carried out according to the law. More on that one later. Lastly, the successor trustee needs to distribute the assets of the trust according to the terms of the trust documents. Here, it's important for successor trustees to remember that they have a fiduciary duty under the law. That is, they have a legal obligation to act in the best interest of the trust and to put the interests of the beneficiaries above their own. Now, there are many things that are involved in maintaining fiduciary duty, but a step-by-step process for trust administration is a big head start. Step one of trust administration is locating the relevant estate planning documents. Of course, this means the trust itself, but it also means the other documents of a comprehensive estate plan, such as pour-over wills, durable powers of attorney for finances and healthcare, and advanced directives for healthcare. Next, the successor trustee will want to locate other important financial documents. Here, we're really thinking about what documents show transfers of assets to the trust. So insurance policies, beneficiary designation forms on retirement accounts, deeds for real estate, and bank account statements. All of that will enable the successor trustee to fulfill his or her responsibility of safeguarding the assets of the trust. Once the successor trustee has identified the relevant estate planning documents, has identified the assets of the trust, they are next going to want to identify the beneficiaries of the trust. You may be going, well, duh, this is kind of obvious. The successor trustee can just look at the trust document which lists the beneficiaries. However, in many occasions, the successor trustee can have trouble because maybe a beneficiary was married and changed their name. Perhaps perhaps a beneficiary moved across the country and has changed addresses. Or maybe a beneficiary of the trust has passed away and his or her children are now taking that beneficiary's place. all those things can make it difficult for the successor trustee to identify the beneficiaries, but it's absolutely critical that they do so. And once the successor trustee has identified the beneficiaries, at this point, they need to be meeting with the deceased professional advisors. This means financial advisors who often have the best view or best vantage point about the investments and the assets of the deceased person, but also the deceased person's CPA if they have one, and of course the attorney who drafted the trust. At that meeting, when I'm talking to the successor trustee, I will outline all of these steps in the trust administration process. I will also typically explain why the estate plan was set up the way that it was. I think this helps the successor trustee be confident in the plan that they're administering, but just to have that knowledge to answer any questions that may come up as part of the trust administration process. Once we have that meeting, we're going to want to supply or mail a copy of the trust document to all the beneficiaries. This is something to which they're legally entitled under the law, and this is a step that cannot be skipped under any circumstances. The successor trustee must mail a copy of the trust document to all beneficiaries. At the same time, to the extent it's possible, I want the successor trustee to have a preliminary inventory that they can send along with that trust document. So not only do the beneficiaries know what the trust says, but they also know what the trust owns. This is a big step in kind of alleviating some of those fears and concerns that beneficiaries will from time to time have. Okay, so we've got the trust document and the other estate planning documents. We've got a rough inventory of the trust based on those insurance policies, deeds, bank accounts, etc. We've identified and located all the beneficiaries of the trust. And we've had a meeting with the deceased professional advisors. Here at this point, we are kind of in a waiting game. So there are many reasons for that. The house, for example, of the deceased may need to be sold. We could be waiting on the cash out of life insurance policies or payment of other benefits that need to come in. So there's kind of a waiting game here. What the trustee is going to want to do at this time is to set up an estate or trust account, kind of an operating account that we can run everything through. This makes the accounting of the trust, which we'll discuss in a bit, a lot easier. So we're going to set up that operating account for the trust, and we're going to want to apply for an EIN, an employer identification number, with the IRS. So that doesn't necessarily mean that the trust is going to be required to file any returns or pay any taxes, but this number is necessary in order to open that trust operating account. The account's open now, and we're kind of waiting on assets or payments to come in. We're going to want to identify the creditors of the deceased, if any. So one of the advantages of trusts over wills, which go through probate, is that they're less prone to attacks by creditors. But this does not mean that the beneficiaries and the successor trustee are off the hook. Debts run with the deceased, so they must be handled. And until they are, the trust cannot be closed. So we can't close the trust, we can't distribute the assets until we handle these creditor claims. What I found in my practice is that this can kind of be a drawn out stage of the trust administration, but it's really also an opportunity because we can protect the trust and the beneficiaries from any future legal claims or really just being hassled by these creditors and collection companies. But two, we can frequently negotiate down the balances on certain debts. So maybe we think that hey, that amount of money is not correct, or the deceased didn't receive treatment at that particular hospital or medical institution. Once these creditors are made aware that the deceased has passed away, they're typically very willing to negotiate down those bills. Okay, so we identified creditors. We've sent the notice to creditors that there's a trust and that we're proceeding along with the administration of it. Um, Next would come taxes. And this is the thing that nobody really wants to talk about. And hopefully, if the estate plan was done rigorously and properly, taxes will be minimized. But here we're thinking about three different types of taxes. One is income taxes. So the decedent's final income tax return will need to be filed. There may or may not be tax due on that, depending on how much money the decedent made in the year of their death, or how long they lived into the year before they passed away. Income taxes can also take the form of retirement account distributions, however. So when a retirement account is distributed to beneficiaries, they must pay income taxes on those distributions. And we're operating at this time under something called the Secure Act. That was put into place by Congress and President Trump in December of 2019. And what the Secure Act says, among many things, is that beneficiaries must cash out all retirement accounts within 10 years of the date of death and pay the taxes on it. So this is really where a financial advisor is very, very helpful. They can counsel the heirs and the beneficiaries on the right way to deal with those accounts, set up inherited IRAs, and the whole nine yards. So we're going to be thinking about income taxes with retirement accounts. We'd also have capital gains taxes. This, is a minimal part of trust administration, because most often the beneficiaries are going to get a step up in basis, which means their tax value in the property is the fair market value of that property at the date of death. So the result is that most of the time there are not going to be taxes due for capital gains, although it's always something we want to examine before we reach any conclusions on that front. And then lastly is the estate tax. So the federal estate tax exemption has bounced all over the map, the past couple decades. Currently, it stands at 11 million plus per individual and $22 million for married couples. So how does that translate into practical terms? It means that you can leave up to $11 million per person to your heirs and beneficiaries tax-free. The caveat here, so let me back up for a second. That means about 99.9% of people are not going to be subject to federal estate tax. The caveat is that situation could be changing. So with the recent election results, there has been banter in Washington, D.C. about lowering the estate tax exemption at the federal level. Some of this could be complicated by the ongoing coronavirus pandemic, which I think is going to take up much of policymakers' attention, at least in the first half of this year. But once we put the coronavirus pandemic behind us, I think that the discussion about lowering the estate tax exemption will resurface. Now, we don't know what that number is going to be. I suspect at minimum it could come down to the prior exemption before the most recent tax law change in 2017. And so that amount was $5 million, which will bring in a whole lot of more people. But I've also heard proposals for as little as a $2 million exemption, which then gets into many, many middle class families. So all something to keep in mind for the future. But kind of circling back to trust administration itself, the main point is that taxes have to be paid and dealt with before the trust can be distributed. And if they're not, the successor trustee could be personally liable for those taxes. Okay, so the tax returns have been filed, property's been sold, we're dealing with the creditor claims. Hopefully we're winding down the trust administration process now. One last thing that we will want to do is an accounting. Now, this isn't something that's required by law. There's no Oklahoma statute, that requires a specific form of accounting. The Oklahoma Trust Act does say, however, that we're going to, have to do minimum accounting. And then the trust document itself is going to kind of guide us here. What does it say? What is the accounting to be comprised of? Is it just receipts and disbursements? Is it significant transactions? How itemized or not itemized does it have to be? I err on the side of too complete of an accounting. So I want to know, the beneficiaries to know every penny that's come in and out of the trust, any significant transactions, what property was sold for how much, what was the benefit to the trust, any sort of fees and expenses that have been paid to CPAs, financial advisors, real estate agents, attorneys, all those things we're going to want to put in an accounting. And we want to also at the same time, attach where applicable bank statements, insurance policies, those other documents evidencing trust transfers. Once the accounting has been supplied to the beneficiaries, there's no real time limit on fully closing out the trust and distributing the assets. One thing that we are going to want to make sure of, if we're the successor trustee, is that we receive a receipt and release from the beneficiaries. What is a receipt and release? So that is simply a document whereby the beneficiaries of the trust acknowledge that they have received their rightful share under the trust document. This is extremely crucial because when I'm counseling a successor trustee, I mentioned earlier in the program that they have a fiduciary duty, and I want to rest easy knowing that the successor trustee is not going to be sued because of their actions while serving as trustee. And so if we have a document that the beneficiaries are acknowledging they've received their share of the trust, they're okay with it, they agree with it, that really takes that future threat of litigation against the successor trustee off the table.
All right, thank you for joining us for our recap. We look forward to seeing you again for our May webinar series. If you have any questions or if you would like to schedule a free consultation time with Tyler, please send me an email at maddie@tylerrbarrettlaw.com, or you can give our office a call. We look forward to seeing you again in May.